5 seconds to go. Start. Personal liberty of a person is one of the oldest concepts to be purported by national courts. As long ago as in 1215, the English Magna Carta provided that signature not verified, no free man shall be taken or imprisoned but by law of the land. Today, the concept of personal liberty has received a far more expensive interpretation. The notion that is accepted today is that liberty encompasses these rights and privileges which have long been recognized as being essential to the orderly pursuit of happiness by a free man and not merely freedom from bodily restraint. There can be no doubt in saying that lodging juveniles in adult prisons amounts to deprivation of their personal liberty on multiple aspects. This writ application under Article 32 of the Constitution is at the instance of a convict accused undergoing life imprisonment for the offense of murder, seeking appropriate directions to the respondent state of Uttar Pradesh to verify the exact age of the convict on the date of the commission of the offense, as it is the case of the convict that on the date of the commission of the offense, that is 10th September 1982, he was a juvenile aged around 15 years. The facts giving rise to this litigation may be summarized as: the writ applicant, along with other co-accused persons, was put to trial for the offense punishable under section 302 read with 34 of the IPC. Secondly, the fifth additional sessions judge Agra in the sessions trial arising from the case crime number 126 of 1982 registered with the Fatehpur Sikri district Agra held the writ applicant herein and the co-accused persons guilty of the offense of murder and sentenced them to life imprisonment. Thirdly, the writ applicant herein and the other convicts went in appeal before the Allahabad High Court by filing the criminal appeal questioning the legality and validity of the judgment and order of conviction passed by the trial court in 1986. Fourthly, the appeal was heard by the High Court and wide judgment and order came to be dismissed, thereby affirming the judgment and order of conviction passed by the trial court. And fifthly, the writ applicant herein, dissatisfied with the order passed by the High Court dismissing his appeal referred to above, came before this court by filing the application. It may not be out of the place to state at this stage that till this court dismissed the special leave petition void the order, the writ applicant herein had not raised the question of him being a juvenile on the date of the commission of the alleged offence. It appears that while the writ applicant was undergoing sentence of life imprisonment, he was subjected to medical examination by the medical board constituted by the respondent state in pursuance of the judgment rendered by a division bench of the Allahabad High Court in the criminal writ public interest litigation number 855 of 2012, wherein the division bench of the Allahabad High Court observed as admittedly, as per the state's earlier affidavits, it was claimed that there were 72 prisoners who may have been below 18 years in age and who are detained in the various district or central jails. Prima facie, there appears to be some material for suggesting that such prisoners may have been below 18 years on the date of commission of the offences. After the modification of the Juvenile Justice, Care and Protection of Children Act 2000 by Act number 33 of 2006 under section 2.1, a juvenile in conflict with law means a juvenile who is alleged to have committed an offence and has not completed 18 years of age as on the date of commission of such offence. Under the proviso to section 7A1 of the Act, it is mentioned that a claim of juvenility may be raised before any court and it shall be recognized at any stage even after the final disposal of the case, and such claim shall be determined in terms of the provisions contained in this Act and the Juvenile Justice, Care and Protection of Children Rules 2007. We therefore direct the district judges who are chairpersons of their respective legal services authorities to directly oversee that efficient lawyers are appointed for the purpose of providing legal aid to the prisoners who have been mentioned in the list furnished by the state government and described to be below 18 years in age on the date of commission of offence. The said legal aid lawyers should get the ages of the prisoners ascertained by obtaining documents and carrying out the other measures provided under Rule 12 of the Juvenile Justice Act and rules, and also on the lines suggested by the Delhi High Court Department of Women and Child Development and others in its order dated 11th May 2012. The probable date of birth of other siblings can also be taken into account for ascertaining the true age of these prisoners. Stop.